in this process, and it's been kind of unfortunate that that's not happened from the SDC, the Save Downtown Canby business folks. Nor have we seen them and really understand who they might be, but we can certainly speculate about what's happening here. So as Mr. Layton said, that site is, and I'll just put it now in lawyer language, remote from the central core. And it is sat virgin for quite some time. And there are reasons why that site won't develop with the current overlay, whether it be my particular client or some other proposer of development on that site. And so the question before you is, does Mr. Layton's explanation for why that site's miszoned, if you will, after getting more evidence and more understanding about how the zoning might work along that corridor, compelling to you? And bear in mind that your comprehensive plan says this is an appropriate process. Making this application for an amendment is an appropriate process, and it's one where this fine-tuning takes place. And I think the evidence before you shows that it is appropriate to make that amendment for this particular site. Now, that's not the end of the inquiry, and I think your staff was very good at the opening to kind of parse this apart, that there's a design review component to this application that occurs if you are to approve this mapping amendment, text amendment. Then there's another process that goes through that does a little bit more fine-tuning, and that's an appropriate process as well. So I think on that prong, and I was happy to hear Mr. Connors agree that we had those two big issues, I think on that issue, we're clearly providing you with the evidence that you need to support this recommendation, or support this proposal by Fred Meyer. On the second issue, I think we've got two lawyers here who simply disagree about what the law requires. I will read you right out of the state law about when a transportation rule analysis is required. And it says, if an amendment to a functional plan, an acknowledged comprehensive plan, or land use regulation would significantly affect an existing or planned transportation facility. And that doesn't happen here. It doesn't happen because the trips are already accounted for under the C2 zone. The C2 zone has a wide variety of uses. Each one would have different levels of transportation impact, different dynamics about times of day that those cars might come in, different numbers of vehicles, different modal mixes between pedestrians and bicycles. But the fact remains the C2 zone allows for that use. And the only thing we're talking about here is a little bit of design flexibility to allow the use that's already allowed in the C2 zone to take place on this site. And that's simply the answer. We provided into the record an October 8th letter from Group McKinsey, a transportation engineer, expert again, that says the same thing. It says that the TPR analysis, and in fact it takes 2 pages, goes through the whole TPR question, and says and concludes the TPR analysis is not necessary, and that the transportation study that we've provided to the city is adequate at this stage of the process. And in fact, your transportation engineers, DKS, who originally, they too are transportation experts, who originally told Fred Meyer what analysis was necessary. They told him what analysis was necessary. Fred Meyer responded, gave the analysis that the city asked for, and that's done. And to bring this issue up over and over and over is essentially, sounds like a law term, but it's a little bit of a red herring. And asking for more than you need to have for making the decision at this level. So with those two issues were the predominant issues in front of the Planning Commission. I think they're easily answered. And I think you've got all the evidence before you to conclude that the criteria for this request has been met by the applicant. And I'd be happy to answer any questions, but with that I would conclude.
Any questions? Thank you, Mr. Abel.
Thank you.
Actually, I've got one.
Okay.
Would your client be opposed to us taking more time than tonight to make this decision?
I guess I'll ask you, I got a little procedural question there. Does that mean that the record remains open?
That would be based upon a recommendation of our attorney, but I'm just wondering from your standpoint, are we under a time deadline? There's a lot of material here. I may have questions that I haven't even created yet, and I'm just wondering if I, in your mind, need to make this decision tonight.
Well, my memory is that the record, our extension period is through the 22nd,
That's right.
which is 2 weeks from now. If you are going to decide to hold it over for a decision at a later date, I would request that the record be closed so that no new additional evidence comes in. We have seen in this process already a kind of dragged out process in front of the Planning Commission with requested extensions and rebuttal times. And I think the evidence is all here, and I would request that under any set of circumstances, the record be closed.
That's
Whether you, as your counsel, wants to make a decision tonight or makes a decision 2 weeks from tonight is something I don't know that I can influence, but I can say that you do have an extension through the 22nd.
That's all for now, Mr. Mayor. I do have some procedural questions of our attorney when we get out of public hearing.
Okay, with that, go ahead and close the public hearing, and now will be questions by the council. Rich, I don't know if you want to, we just kind of go around the
Sure, I'll
corner
start.
here?
I was a little bit facetious when I said I perused the file. I had a lot of downtime since I got home Saturday, and I read the file, every page of it. And the same thoughts that came out of the reading of the file were clarified and reinforced tonight. And just a couple things. One of the comments that Planning Director Brown made this evening was that when this plan was adopted, our long-range planner was only peripherally involved and was not involved heavily. That suggests to me that this isn't a detailed plan as a zoning map might be, but it was a broad brush concept plan where the lines, I won't call them arbitrary, but the lines were drawn, but not necessarily with an eye toward the detail you would do in a more detailed plan like zoning. I heard several times and read in the package about this zone as being a pedestrian-oriented use, and I heard tonight again about the high pedestrian use in that area. And I'm not an attorney, a licensed one anyway, and I don't know what the definition is of high pedestrian use, but from a practical standpoint, until I retired in 2005, I, for 10 years, had a window on this street watching 99 Juniper and 2nd Avenue. And I can tell you for certain that the pedestrians that come off of 99 around the 7-Eleven store at Ivy and 99 come down Juniper and get on to 2nd as soon as they can to walk. They don't walk down 99 because of the safety, the noise, and just the hubbub. As I said in the disclaimer early on, I did own a quarter of this block, and my wife had an office in what is now the Psychic building, where her office window was not even from here to Tim from the highway. And it is not a pedestrian neighborhood. It is a commerce truck route. And the more we can do, and the Gateway Plan has been brought up, the Gateway Plan I don't believe has been finalized, but I will do what I can to encourage pedestrian use, not on 99, but on the side streets, 2nd and on the north side on 1st Avenue. So with that, I don't think that even with speed limit of a 25-mile-an-hour speed limit, you're going to encourage a lot of pedestrian use. On the north side of 99, between Locust and Ivy, you've got Hulbert's, which could have some pedestrian traffic, but except for that one, all the other businesses are auto-oriented. There's the Chevron station, there's the auto repair shop, there's the in-out mini-mart, and there's the lube and car wash. And so, and the others along the same block between Locust and drawing a blank, except for the Psychic building, the others are auto-oriented. This is Cleaners and Domino's in-out. So I think that my personal opinion is we aren't adding any more problems. I mean, traffic patterns will change some there, but I personally see that this is a reasonable request to make, and I'm prepared to support that if you want to make a decision tonight. So.
Okay, thank you, Rick.
Much of what Councilor Ayers said, I concur. I've kind of gone over this very large packet, and I've seen both sides. Both sides make a good point, but I do come back to the point being made about the Welcome to Canby sign, the gateway sign. Doesn't really indicate that you are coming into downtown. It doesn't say downtown until you get to our actual gateways of Ivy Grant and Elm Street. It just tells you you're coming into Canby. It isn't downtown. It is a highway, so I tend to agree with Councilor Ayers that we're not really wanting to encourage pedestrian traffic in that area. Initially, I thought we were talking about whether or not it should be a gas station or not, and I realized we're just moving a line that we don't really know how it got there exactly. There's some debate on that. So my only question on the line is why we're going to move it mid-block. From Locust, maybe it should be moved to not, and not. I don't understand the logic in doing it mid-block. I guess that would be my only question in where we're putting the line. And it was a design task force, not a boundary task force, so maybe they weren't really sure where they were putting the line in the first place as far as where the design standards should be that they were creating. And it's not the role of government to pick and choose commerce, so I'm glad we're not deciding on whether or not it should be a gas station. I would, at this point, I think, I would like to know why we're putting it mid-block. Other than that, I don't support putting pedestrian areas on 99, so I would support this, I think, unless somebody gives me something new to consider. Thank you, Mr. Mayor.
It is an interesting piece as we're going through this, and a lot of conversation that we've had as a body. Where do we begin? Where do we end with 99E, and where do we want it to start to identify our community? Is it Locust Street? Is it the bridge? Is it out by Sequoia? I agree with the two previous counselors in that there is not a lot of pedestrian activity. I too get to look out on 99 on a regular basis and see a handful on a day-to-day basis walking. What I understand tonight to be about, though, is this boundary of a design standard overlay, correct? That's what we're discussing? Not that whether or not a gas station can or can't go there because of the code. Hey, if that's the business that's being looked at and being decided upon for those business owners and those landowners, that I'm fine with. At the end of the day, competition will decide who stands tall and who doesn't. That's not for us to say who. We might as well then figure out how many coffee shops we're allowed to have in Canby. Why is that funny? I like coffee. Let's bring in some more. That's fine. So what I want to try to figure out, or what I want to understand, is if we're going for a certain look when we come into downtown or coming into Canby, does this design standard meet that, and can Fred Meyer meld or design a gas station that meets that design standard? That, I think, is what we're trying to decide upon, right? So if we move this line up, whether it's the half, just the property line, or we take it to the next street, we're now changing what that design standard is going to be.
But we're also not really discussing the design standard tonight. We're supposed to be,
I understand that, but there's a design standard in place within this
It's
overlay.
different design standards between the two.
right.
Absolutely. So what we end up with is something similar to 76 or something better.
Which is the picture she had up on the,
Potentially, that may be it. So I'm not for changing the design standard that we have. A gas station can go there, that's great. If we're gonna, at what point do we start to make 99, if everybody keeps talking, we've had conversation here on what does 99 look like, and what's the tone we're gonna set for our community? Well, do we wait until the next project comes up to decide what that tone is gonna be? And maybe that's not the next project, and we keep, if we're gonna get a new precedent set here and changing this overlay, then it will end up being consolidated much, further down, as I think one of the gentlemen was mentioning. So that's where I'm trying to understand, again, if our scope is, we're not deciding whether or not a gas station can go there, it can go there. We're just deciding, where's this design line go? And there's been conversation already on the challenges of the design code. We live and we learn, and we need to look at it, and I understand that that's being looked at. Okay, so we have something in place, and I think that we start creating a slippery slope for us on each application within this design area. So, in terms of specific questions, they've all been answered for me in terms of, as I posed to everybody here, is where do we want Canby to begin? To Rich's point on the south end, yeah, I see most people walking on 2nd Avenue. I'll go visit Bev at the chamber office, and there's a heck of a lot of people that walk down 2nd Avenue versus 99. So those are my opinions.
Paul?
The years I've been on council, this has been a confusing issue because I never seen them bring design review material to us. We've always gone through a process, and I think that regardless of saying disregard that, you can't help but look at some of that stuff and say, if I do this, this will happen. And I think that's just the thing that's bothering me tonight. One of the things is, I was around when we were doing this process. I was not on the committee, but I could see the process. There was a reason why they put that design, the overlay on it, was to protect that. And at the time, there was some talk, people were saying, well, we were putting an office building in or something like that, that'd be fine. I don't think there's a discussion to say, well, what happened if somebody wanted to put a filling station in there? Sure, that this zone, C2 zone allows that. But the thing, I'm not against business, coming in, but I think, again, it's hard to look at all the traffic that's congested with all the other business along there. I remember the time when the mini storage was put in there. Boy, that was a hassle for a long time because ODOT said you can't come out on the highway. And finally they come out, the point was there was an old building there and there was a driveway went in, and so they said, well, it was grandfathered in. Okay, but you can only go out right. You can come in. And so we look down the street here and we've got so many businesses along when we walk, as you know, gas stations and repair shops and auto parts and all that, all trying to get out there. And all those can go left turn out on the highway. Yeah. If we were to approve this thing tonight, allow them to do that, then they go back to the planning commission with design review and it's turned down. Here we've got a change here. And I saw this happen with Canby Square. There was a years ago, when I came down, they wanted to put in an auto sales there. And finally went through, changed the zone, and then it fell through, but zone stayed there. And all at once, they made an application for Canby Square, and people said, well, wait a minute, well, it was changed. It never gone back, so that's a concern I have if we change this, because there was some protection by the people that were on that task force at that time to protect us. Now, I realize that someone here said that there was not much pedestrian traffic. I walked it, and that's a little problem, it's narrow roads because people are riding a bicycle. But this was a plan set up for improvement of 99, and we're working on that, and then, which would give the larger sidewalk and speed limits would drop down. So again, I think that if we allow this to be overridden, what keeps somebody from coming in and say, well, now you did it down here, what about the other end of town? There's a lot of places up there where we can tear down an old house or do various things and put that kind of thing in. So I would rather just leave it the way it is and deny the override.
Well, we don't have a motion on the floor, so I guess I'll withhold that type of discussion unless and until we do. I have a question, which is, what is the criteria by which we are to make this decision? I mean, there's got to be some boundaries here. I can't just say that I liked Angie's picture and I'd like to have 99 beautified, and that's what I want to get, and if I vote this way, I'll have a better chance of getting it. But there's certainly, since we are in a quasi-land use arena here, there's got to be some legal guidance here on what we should be making our decision based upon.
Well, I'm going to defer to Brian on the land use.
So basically, you have those 5 criteria, and you have one additional criteria with the map amendment, which is, will there be adequate infrastructure to serve the new use or types of uses or designed uses that would occur if you change the boundary to a different sub-area.
And do we have that information in our testimony? Because I don't think that was covered, at least in the oral testimony.
Staff report in your packet.
Okay. I must have missed that.
I gave a little thought today too, and I guess I could just go ahead and share with you. It's nothing outstanding, but one of the ways that I've thought of this from the question that you've just given is what's the criteria is to think of it in more of a practical term. We've got our criteria that the code says you need to evaluate this by. If you use it in practical, I would say that you need to consider if changing the development standards or design standards that are applicable to this particular property today, if you were to move the sub-area boundary as it's being proposed, would those new design standards or design guidelines harm the intent of the downtown overlay district?
And I guess, how does that relate to the pros and the cons? How do they relate to a public need for the change, whether they will serve the public better than any other change which might be expected, health, safety, and welfare, the basic police power of a zoning ordinance. So I guess weigh all the stuff that you've heard tonight in the perspective of those criteria. They're broad criteria, but those are your criteria.
I know we have to do the heavy lifting, but
Yeah.
thanks for trying.
Yeah, as with Councilor Parker, I have a few questions. What is the city's position as our lawyer, as our planning department, on this question about the TPR being needed? This is a big deal to me that stood out strongly as I read the documentation. Do we need one, or don't we?
The city does have a position with regard to that, and it's basically the explanation you just received from the applicant's attorney and that we hire a consulting traffic engineer specifically to help staff make these decisions, and consulted with that traffic engineer. And his professional opinion was, similar to what Mr. Abel indicated, that there was no significant impact being proposed with a sub-area boundary change that would demand that a TPR analysis be done. Therefore, staff isn't in the business of asking a whole lot more of applicants than our code actually appears to request of them, because that's unbusiness friendly for us to gather unlimited amount of data when it's not really called for by the code. And so we didn't feel like it was necessary. It could always be desirable to have as more information, oftentimes is better. But we didn't feel like it was necessary because we don't see the increased impact over and above other allowed uses that would be permitted on this property. And our transportation plan has already taken into account reasonable worst-case scenarios when they did the transportation analysis, deciding on what the projected impact for 20 years would be for the various intersections. They took into account this property fully developed with a reasonable worst-case scenario, and we know what the outcomes of that is that in 20 years we may have some traffic problems at our major intersections, but it's been accounted for and assessed.
Okay.
This is one of the design issues that the Planning Commission will deal with when they deal with the site plan and design review, if they have an opportunity, is they'll weigh whether the driveway locations and those kind of things are adequately addressed. And that's what the traffic analysis study does tell us and makes recommendations regarding that.
So in our packet, we see a rather lively discussion between 3 different traffic engineering firms as to the study, its validity, its quality. It was very interesting reading. It would seem to put the city in a position of disagreement with the applicant study. Where will that battle be fought then? Will it be in the site design? And if we change the development overlay, do we hamper the planning department or the planning commission in their ability to deal with those traffic issues in the design?
I guess I don't feel like that it hampers them in any way.
It doesn't prevent planning from, I'm just using an extreme example here, from saying, we're sorry applicant, you're going to have to go with one-way traffic.
Well, by you changing the boundary, you're not making those kind of design decisions or anything.
Okay, that's what I'm after. How are we binding the planning department and the planning commission?
You're really not. So I don't think changing your boundary, if you were to approve a change in boundary, is any way setting a direction or saying anything other than go forward with a design that meets the code design and development standards that are applicable now to this new proposed sub-area boundary, which they've already done because the application they submitted for site and design, their development plan, assumed it would be changed. And they submitted a design that meets the proposed change they're asking for.
Alrighty. And then as a related question, I have the same concern as Councilor Hodson about the look. When is the look maintained? When does the look change? If we were to grant the design overlay change, how does that bind, I'll say, or hamper the planning department and planning commission's ability to make the requirements on the cosmetic appearance of the facility?
Well,
let me give you a hint of where I'm driving. Are we stuck with how the 76 station looks? Or can it look like something compatible with what our desires are? Cultured stone,
Yeah.
nice wood, the Costco fueling station.
Well, there's kind of two answers to that. First of all, you do have to recognize that filling stations are a kind of unique use.
They are indeed.
And because of that, they're taking advantage and will need to take advantage of the flexibility that's within the downtown overlay guidelines that give them and the Planning Commission the ability to interpret that the intent is being met. Because if you're not even building a building, it's hard to meet some of the design guidelines, in other words. But one of the characterizations you were mentioning, Councilor Hodson's, one of the characterizations that maybe I wouldn't 100% agree in the terms that if you change the boundary, you're not necessarily talking about different quality of development. You know, you're not relegating the property to less quality. You're relegating it to the application of different design standards to achieve a different look. It's not necessarily less. It's a different objective. And that's what the downtown, why it has 3 different sub-areas. One is supposed to be higher density, pedestrian-oriented, close to the street type development that gives that enclosure, whereas the other sub-area is wider, set back from the street, auto-oriented, and that kind of thing.
It still
Both
requires-
can be beautiful and done well. And they're going to be done better than the existing uses because we have the design standards in place
So the others
on
were
either
built before
one.
The standards, right?
What's that?
The 76 was built long before the standards were in place.
And so that's
The
why I'm
current
after.
standards.
If we do move it, we're not preventing our own planning department and commission from saying, Fred
No.
Myers, we want earth tones. We want some cultured stone on the kiosk.
Those design standards are still there. You just have to be aware, and I can't tell you exactly all the differences here. But there are differences that will apply. And so one building on a lot that's in the outer highway commercial sub-area and a lot that's right next to it that's in the core commercial, if they were the same use, not a filling station, something else, they might look a little different because the standards are different.
No, I understand. You see where I'm going? Though I'm trying to figure out the impact of moving this on our own planning
So
department.
are we going so strict versus less strict?
Right.
And that, because as you were talking, I wrote down, my question is, so what specifically is at issue for the applicant, Brian, that, with the design overlay versus if we roll that up, what suddenly changes for them that makes this property and this more feasible than the overlay?
Do you have, I think, didn't you email the intent, the purpose statements of the 2 zones around? or-
Chapter 16.41 has a purpose section, a 2-page purpose section.
So the purpose of the core is pedestrian, the purpose of outer highway commercial is auto. So on the outer highway use, they still have higher quality materials standards, landscaping, lighting, but it can be auto-oriented in use and not for, the core commercial is pedestrian-oriented, which this proposal is definitely auto-oriented and not pedestrian-oriented.
So that's why we originally, at a pre-application meeting, suggested that if you're going to, since we saw what their design was, we said, oh, this is kind of auto-oriented, like a typical filling station. It will fit better by the intent of our overlay district if it was located in the outer highway district. And you would have a better chance of approval by the planning commission if you submit it, if you're in that district. Therefore, they're proposing to change the boundary, so it will be in that, so they have a better chance of approval by the planning commission. And so, to me, your valuation is thinking of the comprehensive plan or your downtown overlay. They're kind of one and the same. They're objectives for this portion of the highway. What do you think your comp plan and your downtown overlay was trying to achieve? Is this going to be detrimental to effectuate a change for this one lot or not?
No, I get it. I just wanted to make sure that we were not, by relaxing that development overlay, that, I was trying to figure out what we're giving up.
Right.
In terms of our own ability to help work with Fred Meyers to dictate
Sure.
a cosmetically appropriate look for the city.
I think when I'm taking it from it, if we move the zone, they can put a kiosk in, where if we don't move the zone, they have to build have to build an actual building, which is not part of most gas stations. I mean, they are on some, but not on.
Probably a reasonable
Right.
conclusion.
Yeah.
They would-
And I'm okay with the kiosk, but are they able to say, look, guys, it's going to be sheet metal and white, and there's nothing you can do about it? Just let me be practical.
I think planning will be able to have that, because our codes
That's what I'm
aren't.
after.
I don't believe would
Does
allow.
our code say, nope, it's going to be earth tones, and you're going to put a lot of decorative line of brick around it like a doily?
It gives the planning
and-
commission the authority to
Okay.
require something
So we're
like
still
that.
going to be beautifying 99, just
It
Right.
wouldn't, it would
A
not,
different-
it would probably look different than the 7-Eleven.
76
76.
stations across the
Okay.
street. Okay, so so with that
It would
argument
be a
then,
little higher quality.
what's in the toolbox of the planning commission and the planning department, that if we don't roll this back, that they come and go, here's the design we want? How do we achieve that? Is that an exceptional, we go through and start creating exceptions? Does that create a bigger pot?
A worse mess.
Pardon me?
A worse mess?
Yes, I mean.
Because of by exception.
But because we
changing
keep
policy.
the overlay, we've got this piece intact, but now we take something and we go, okay, so we're gonna make this exception, great. It can be a kiosk that's not sheet metal and white, and we can move it off the street versus a building that's up front that looks like that up there. Though better than what we see in most gas stations.
Right.
Still not what I would be rip-roaring excited about necessarily, but does that make, I mean, how do we,
Can
Does
we
that make
get
sense?
there? Yeah.
can we get there, can we get there without rolling back this overlay?
It's kind of interesting, the terminology in their application is a fueling center, not a gas station. And I think we have different compensation of it. If you look around town and say, well, do we have any fueling stations? We'd probably go up behind Dairy Queen and say, yeah, there's one. No, there's no
no.
buildings.
Yeah, I
Does
think
it
the
go
other
to
one
Carson-
would be the other
Carson?
76 station farther up on 99. That's more of a fueling station. It's got a kiosk. It doesn't really have a main building that like
Well,
the other 76 stations actually got a food mart and stuff in it now, where the other one down at the other end does not
The
have.
Chevron station, almost across the street from this spot, blocked down, I guess, they have basically a kiosk.
Yeah.
If you don't look at the garage that's next door, which is separate, but it's, a canopy and a small, what I would call a kiosk. And,
So do we make a bigger mess?
Well,
Like
from a
treating-
policy perspective and writing software perspective, I'd far rather change policy and have a clean than I would take something we have and do exception patches.
Okay.
Does that make sense?
Absolutely.
That's
I
why
asked
I
the
meant by
question.
make
I
the
mean,
mess worse.
No, I agree.
So, that all being said, I'm not trying to keep Fred Meyers in nor out. It's
Sure.
not for us to decide. I deeply, I appreciate how well it was articulated. I deeply appreciate process and what goes into forming the language that memorializes intent. And in the end of the day, when it gets into court, that's what we have to go on, is what was written down. On the other hand, this isn't the Constitution. It's a 150-foot move on a perimeter. And we are the guys that can change it. And I can be persuaded to do that, as long as we don't give up our ability to keep a look and feel that we want. I totally get that for Fred Myers, that a pedestrian-friendly fueling station is not compatible with their business plan. It doesn't give them the capacity they want at all. Cost aside of development, it doesn't give them the revenue stream they need. And I totally get, that's why they're here. That's why blue signs go up for zoning changes, because somebody wants to do something different. They see a better opportunity. I just want to make sure that we can keep the look we're after and do the right thing.
We keep kicking this around for a long time. We do have an ordinance number 1365 that addresses this on page 266 of 280.
There's that size again.
Let me put this on the table so that we have something to go on and vote on. The ordinance that the mayor just referred to is that we have a choice. We can either uphold the planning commission's action, or we can adopt an ordinance that has the findings in it, and the staff was prepared as that in case that was what we decided to do. So I will make that motion to adopt ordinance number 1365, an ordinance amending Title 16, Chapter 16.41 of the Canby Municipal Code concerning the sub-area boundary of the Canby Downtown Overlay Zone.
Second.
I'll second it for purposes of discussion.
Okay, it's been moved by Councilor Ayers, second by Councilor Parker to adopt ordinance number 1365, an ordinance amending the Title 16, Chapter 16.41 of the Canby Municipal Code concerning the sub-area boundary of the Canby Downtown Overlay Zone. Comments? Let's start telling this in, I guess, this time. Go on. Sorry.
Still trying to get wet again.
Sorry.
I'll defer to Greg.
Okay, great.
Well, I've got a lot of thoughts. Some of them have to do with how lucky we are to a city recorder that's doing a better job these days of capturing our intent. So 10 years from now, when our successors try and figure out why something was done, they may have a better time. I'm frustrated by the fact that we don't have a more precise reason for why this was put in place. I'm being asked to change something, and I don't know why it was done in the first place. I'd love to have a pedestrian-friendly 99, but within my set of priorities versus realities, I'll settle for a better-looking 99. And Councilor Hensley and Dale were helpful in getting me there. That this is going to be a better-looking situation than what we normally think of when we think of a fueling station. And I'm going to count on the Planning Commission and our planning staff to develop something that will help set the standard for the future. There's always the question of whether we want to just have things the way they are, or we want to be aspirational and really have 99 be beautiful. And I'd like it someday to be beautiful. So I think we can get there by doing this.
Any other comments, Sam?
I think that one of the things was that as long as I lived in Canby, this has been the entry. I mean, some people look at it and think it's just something new because they made it out of block instead, but it's been board with, put up by Qantas, I don't know how many years back, and had one on the other end of town. It's the entry to that direction. And so I think that sometimes, you know, we can't foresee all the little things that may come down the road, but I think that the people who were involved with it at the time made a reason why they put that overlay zone there for it. Otherwise, why would they have done it? Just left it as a C2 zone.
Well, I've got two real quick comments. One, something that Walt said earlier reminded me of why I think the pedestrian zone along 99, or building that into a pedestrian-oriented zone, doesn't work. It's almost winter time, And I mean, it's fall, and we're almost into the time of the year where they're sanding the roads and such. And because of the closeness of the highway to the sidewalks, I want to tell you about the shovelfuls of gravel I used to scrape off the the sidewalk that people would have to walk through that's kicked up from the highway, particularly during the wintertime. So that is, you know, another practical thing in my mind of why it shouldn't be overly emphasized to make that pedestrian boulevard. And the other thing is, I think we probably have representatives of Fred Meyer here, and I think I would second what other people were saying here and encourage them to go the extra mile, not just meet the intent of the design standards, but the spirit of the design standards and the textures and the look and the feel and the stone pedestal or basis to the signs and things, and make it something that they are proud of, but also that we can be proud of. And so don't just do the minimum. Do what's right.
Okay, any other comments? If not, all in favor of ordinance 1365, say A.
Aye.
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 Nays?
Aye.
So it's 5-1. Okay, that does pass, and Fred Meyer, at this time, we'll now go back to the Planning Commission, and I believe, Brian, you did say that we have the exception letter to say that they have now time to work through that. We don't have the 120-day rule. Is that correct?
It was presented to us in writing today that they extended for the site design review until January 31st of 2013.
So it's back to Planning Commission for design review now. Thank you. Thank you, guys.
Thank you, appreciate it.
And Mayor, I think we skipped the chief's request for some Tahoes. Do we need to go?
No, we're not there yet.
They just have an ordinance.
We're done with the public hearing.
We took the ordinance out of it.
Yeah,
We took the ordinance out of order
did the
to wrap it
ordinance
up
out
and
of
let
order
them
because
go.
of the public hearing.
Yeah.
Okay. I'll let, clear out.
And while we're taking this time to clear out, let me point out, I thought Angie did a terrific job. She's been here a year and this is her first time. So thank you for the effort.
Nothing contentious so far up to this time, so you're now in the middle of it.
Thank you.
Thank you.
Okay, we now have ordinance.
First item we have is ordinance 1364. This is actually before you for second reading. It's authorizing a contract with Hubbard Chevrolet, Wilsonville Chrysler Jeep Dodge, Wireworks of Salem, and Ford Motor Credit for the lease purchase of one 2013 Chevrolet Tahoe and one 2013 Dodge Charger with police equipment packages.
Mr. Mayor, I move for passage on second reading of ordinance 1364, authorizing contract with Hubbard Chevrolet, Wilsonville Chrysler Jeep Dodge, Wireworks of Salem, and Ford Motor Credit for the lease and purchase of one 2013 Chevrolet Tahoe and one 2013 Dodge Charger with police equipment packages.
A second.
It's been moved by Councilor Dale, seconded by Councilor Hensley to adopt ordinance number 1364, an ordinance authorizing the mayor and city administrator to execute a contract with Hubbard Chevrolet of Hubbard, Oregon, Wilsonville Chrysler Jeep Dodge of Wilsonville, Oregon, Wireworks of Salem, Oregon, and Ford Motor Credit Corporation for the lease purchase of one 2013 Chevrolet Tahoe and one 2013 Dodge Charger with police equipment packages for the Canby Police Department and declaring an emergency. Second reading.
Councilor Ayers?
Yes.
Councilor Hensley?
Yes.
Councilor Hodson?
Yes.
Councilor Daniels?
Yes.
Councilor Parker?
Yes.
Councilor Dale?
Yes.
Passes 6-0.
The next item we have is ordinance 1366. This is amending the Canby Municipal Code, section 9.24.060, regarding drinking in public places. And Jamie, our Main Street Manager, is here to present this item.
Jamie Stickle, Main Street Manager. It's my first city council meeting as well, although I haven't been here as long as Angie has. With the Main Street program kicking off its committees, in the promotions committee, more than once it's come up about the idea of fundraising through special events. Lots of other cities fundraise through special events in their downtown cores, but a lot of times the key moneymaker there is the selling of beer and wine, usually in some sort of garden, most likely on a case-by-case basis. And so when we took a look at what the code allows and doesn't allow, we found that at this time, other than with a sidewalk cafe, it's not allowed to have alcohol at a special event. So what we brought forth is kind of amending 9.24060 to basically the ordinance reads right now, no person shall drink or consume alcoholic liquor in or on a street, alley, sidewalk, mall, public or private parking lot, or public structure, motor vehicles, public grounds, or other public places unless the place has been licensed for that purpose by the Oregon Liquor Control Commission and the owner of the OLCC licensed premises has obtained a permit from the City of Canby to operate a sidewalk cafe. And the recommendation is to add and other qualifying event. It would be something, again, on a case-by-case basis. And then the idea is that the organization, whether it's Main Street or the Chamber or another organization or even business that wanted to have a special event with alcohol, that there would be follow-up things that they would have to do, like get a special license through OLCC that they offer for events like this, get the appropriate security if that is something that you felt would be needed through the permitting process, and then also the appropriate insurance.
Can you give us a for instance or an example where this would apply?
Just, you mean a for instance event?
Yeah, like.
So let's say we decided that we wanted to do a Shamrock fun run through the downtown and at the end drink green beer and have a beer tent. That's something that...
Sold.
Okay.
I like that. That sounds like that's my kind of running event.
I have a good example of what was envisioned when we built Pioneer Plaza, which is the defunct public use parking lot across from Parsons, next to the Holly Mall and Credit Union. The intent of putting that in was to have that available for public groups to close off and have public gathering kind of things and have a beer tent or a wine and cheese, a community gathering of some sort. And I didn't realize there was an ordinance precluding that, but I mean, we did that back in late 90s and with the idea of that that lot being used for that purpose. So that I can see the need, or the public.
Let Council Parker have the honor.
Well, given the lateness of the hour, let's see if I can expedite the discussions. As liaison to the Main Street Committee, this is one of the ideas that I came back from the National Main Street Conference, in that a lot of Main Street organizations use this. In fact, one famous one that's about the same size as Canby has 2 events a year, and that's enough to completely fund its Main Street program. And my vision and my promise is to try and is to move the Main Street program off of city funding to have it as a 501c3, and this will help get us there. In terms of control, public safety, that sort of thing, our attorney can speak to this more, but I had 2 extensive conversations with our police chief, who has experience with these type of ordinances in Portland. What is before us is the policy question. You guys hear me talk about that a lot, of whether we should do this or not. Behind this, then, will also be a procedure that the staff and the chief will work on that will provide further guarantees. The reason I like the ordinance being general, so that as we go down the road and we find we want greater controls, additional controls, that sort of thing, they can be handled through the permitting process without coming back to us and us tweaking it. So here before us is the policy question: do we want to have this happen? And then staff and the chiefs agreed to be a part of this process, is to look at all of the safeguards that are necessary. He said he's had experience with this in Portland. has no concerns about it.
Question I have for Joe is the parks ordinance that we have says no drinking in our parks. Does this override that?
Well, this does, because what this ends up doing is, as Ms. Stickle wisely pointed to, is that this piggybacks on what we do when people start drinking in public in town. The sidewalk cafes are only allowed because OLCC has a say, and then we have a permitting say. And so this will allow for people, if they qualify, and Councilor Parker has wisely put that it allows us some variance for what the permitting process will look like today, and maybe it changes tomorrow. But the permitting process defines, or will define, what is qualifying and what will be permitted. And so this will allow for this to happen, but in a controlled setting. And I too had a conversation with Chief Brett Smith, and he wanted me to voice that he has the generalized police concerns that people don't go and have a kegger in the middle of the park, but they would have to go get, first of all, we'd have to decide what would be qualifying, and whether whatever intended use was actually permitted by us, whatever structure we put on that, whether it be deposits, insurance, stuff like that, and that OLCC is going to be regulating whoever's, passing out the alcohol.
So even though it says in our ordinance that no drinking alcohol in our city parks, that does override us. We don't have to make another.
But except that it's not permitting
Right,
Joe
I mean,
to take a
right, no, I understand that. I'm
six-pack
just saying,
of
this,
beer.
I
Right, but if we
guess
wanna
I was
vote-
always thinking it was a bigger, no drinking period in the parks, if we had to rewrite those ordinances. But if you say no,
Well,
no.
and what I'll do is I'll go and, when you have two competing ordinances, right? I mean, you can decide for one what the intent is of the legislature and what they wanted when they passed those ordinances. And this would be a perfect case where I would happen to be sitting in the room, I'm the prosecutor, and I would happen to know what your intent is now, which is when OLCC makes them cordon off the area and control who goes in and who goes out, that effectively doesn't even become a park. But it also, because there's a limit to who can go in and out, all of that. But I mean, I can also change it or help you change it if it ends up being a conflict that we can't live with.
Right, so
But I
if we
think-
wanted to have a wine garden or some such thing, say at Slice of Summer, it's in our city park, we could still do that with this ordinance. We wouldn't have to change the park ordinance, or do we?
3 years ago, we did basically this same thing for the adult center, when we opened up and let the adult center have their wine and weddings and things with wine. And so we've kind of made one step toward this already.
So we left the parks out, but then the other thing was, what about Canby Days? How they qualify if somebody wanted to put a wine garden in there? Would this be like coming in for a special permit?
Well, and the other thing I can say as to this other point and kind of build on yours is that since we're just saying in a blanket way, other qualifying event, maybe as the way the code's written, maybe that isn't quite qualified yet in the park until we go back and maybe add those few words that say unless you're a qualifying event to the other code too. And I would be plenty fine to bring that forward.
But that really doesn't have anything to do with what we're doing here.
Exactly. Right now, we can call it a qualifying event and not offend anything because we still need to, as staff and with the police, work on what does qualify and what will be permitted.
Family reunion or whatever it is. Then a process to go through to get permit from the city or something that,
Correct.
okay.
Okay.
Do we have a follow-up that comes back to us to define qualifying event, or is that able to be handled?
I take direction
We
from
have a
you.
we have a policy question, we have a policy question,
Yeah.
which is to go do
Wouldn't it
this.
be a common ordinance though?
Well, you don't have to have an ordinance for this. You can agree on, kind of administratively how, you've passed on a lot of those powers to staff to kind of create policy. But what we can do is, I can take direction from you guys in any which way possible, which is I will keep you not only posted, but I will, take whatever you tell me and run with it, so.
Well, I